Good morning, Your Honor.
Good morning, Officer Milton. I hope you're doing well today.
I am doing well. Thanks for asking. How you doing well, sir?
I am. Thank you also. Who do we have this morning?
I have under probation revocation calendar, position 1 and 2, Sheila Atkins.
Okay, I think that we are still waiting for courtroom 2 to come online. Oh, there they go. Okay.
Your Honor, Mike was just a quick trigger finger.
Good morning, everyone. Let's see. This is in ACDC position number 1, Sheila Atkins.
Yes, sir.
Yes, good morning, Ms. Atkins. I'm Judge Eric Morrow. This is your probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Let's see. Do we have anyone from probation on as of yet? So,
Your Honor.
okay. Thank you, Ms. Champion. As soon as someone comes on from probation, Ms. Atkins will be with you. Okay, so if you'll just give us a moment or two.
Yes, sir.
Let's see. Anyone in courtroom 2 that we're ready to take? Good morning, Ms. Vigiletti.
Good morning, Your Honor.
Your Honor, we're gonna go with position number 2.
Okay.
That would be Mr. Bacon, Jameson Bacon. Do it. Yeah, he's good. Hold on.
And what are we doing with Mr. Bacon this morning?
Mr. Bacon would like to enter a negotiated plea this morning.
Okay, very good. Good morning, Mr. Bacon. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Good morning, Ms. Falk. Oh, good morning. And Mr. Bacon, if you can raise your right hand for me. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, Your Honor.
Thank you, sir. You can place your hand down. Yes, Ms. Falk.
Yes, Your Honor. The state's recommendation is 24 days, credit for time served, release time served, balance suspended, stay away from 3393 Peachtree Road Northeast.
Ms. Vigiletti?
Yes, Your Honor, that's our understanding as well, and we do stipulate to venue basis and factual ID for the purposes of the plea.
Thank you. Mr. Bacon, it's my understanding that in case 21 CR 006598A, you wish to plead guilty to theft by conversion. Is that correct?
Yes, Your Honor.
Are you under the influence of any drugs or alcohol this morning?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Very satisfied.
You understand that you have a right to a trial by jury on this charge, and that by pleading guilty to it, you're giving up your right to a trial by jury?
I understand that I'm waiving my rights to the jury.
Thank you. Has anyone forced or coerced you to plead guilty?
No, Your Honor.
I'll accept the plea as negotiated, Mr. Bacon. Good luck to you.
Thank you, Your Honor.
Thank you,
You're
Judge.
welcome.
Appreciate it. Next, Your Honor, we're gonna go to position 17 and position 18, Andre Hill.
Okay. See, good morning, Mr. McLean. Do I need to arraign Mr. Hill?
Let me look down the calendar for just a moment, Your Honor. 17 and 18. 17 and 18. Right, Your Honor. We will, on number 17, he's not incarcerated on that charge. On number 18, it is only an FTA that is probably associated, no doubt associated with 17, but the only thing on his booking sheet is number 18 as an FTA. Now, the bond request is based on the fact that on December 6, 2023, he was incarcerated elsewhere and therefore he could not have made court that day. He has been in continuous custody since then and has not been free since prior to December 6th. So he would ask the court to give him a signature bond or I could ask the state to dismiss it, but we've got to get some proof. And that proof is going to come either through getting Fayette County Jail to give us some documents or any other level of proof that the court would allow.
Okay, well, if you want to get the proof to Ms. Desiano for them to reconsider, then I'm happy to give you that opportunity to do so. When do you think you can get that proof to them, Mr. McLean?
If we have a break this morning, it's possible. We don't have that many clients. It's possible we could do it by the end of court today. It's just
Okay. Well, if you all can get a consent together, Ms. Desiano, I take it that if he provides you with adequate documentation of incarceration, that your office would possibly consent to a either reinstatement of the bond or a signature bond.
Yes, Judge, of course.
Okay, so we'll give you that opportunity, Mr. McLean. So just reach out back to Ms. Desiano, and if you all want to present me something later in the day, I'm happy to sign it.
Thank you.
All right. Good luck to you, Mr. Hill.
Yes, sir.
Next, Your Honor, we got position number 25. Mr. Rashad Miller, Rashad Miller.
Okay. Do we know what we're doing with Mr. Miller this morning?
ASG Desiano, I did send over late last night a counter offer for Mr. Miller. Not sure if you got a chance to take a look.
One moment, Miss Vigilante.
I'm also happy to, discuss this as a possible non-negotiated if needed as well.
And Miss Vigilante, based on his history, the state is not willing to lower the proposed offer to serve 60 days.
Okay, then I believe, Your Honor, we'd like to discuss the possibility of a non-negotiated plea this morning.
Okay. Given that it's non-negotiated, let me get the history first. Do we have anyone on from pretrial as of yet?
Not at this time, Your Honor.
Okay, thank you, Ms. Champion. Do you have the history, Ms. Desiano?
I do, Your Honor. This defendant has 3 cycles out of Wisconsin, 3 cycles out of Florida, 14 cycles out of Georgia. He has convictions from 2023 burglary, 1st degree, a 2023 probation violation, a 2023 battery from the state of Florida, a 2022 violating a TPO and criminal trespass out of Georgia, and a 2018 conviction for battery out of Wisconsin. He also has several arrests from 2023 that appear to be open, FTAs, bond violation, fugitive from justice, giving false name, and battery. He also has an arrest from 2018 for aggravated stalking and criminal trespass. And Judge, in this case, this incident occurred May 19th, 2024. Officers responded to 2808 Peachtree Park Drive Northeast about a prowler call. Upon arrival, the officer met with the caller, whose name is Mr. Ryan Brumfield. Mr. Brumfield reported that he was walking his dog when he noticed a suspicious man walking into his neighbor's porch. Mr. Brumfield stated that he walked around the side. He heard his neighbor scream and immediately called 911. Upon speaking with the victim, whose name is Deanna Garcia, she explained that she was in her home and a man came onto the porch of her apartment or condo. Her boyfriend confronted him. The man said, the defendant said he was searching for food and shoes, and he took a bag from the porch and left. He was eventually apprehended later. The state's recommending a 12 months on count 1, the loitering, prowling, 12 months probation, served 60 days, credit for time served 16 days. That'll be from May 19th, 2024 to today. Balance probated, no further contact with Deanna Garcia, a stay away from 2808 Peachtree Park Drive Northeast in Atlanta, and 40 hours community service. On count 2, the giving false info to law enforcement. Oh, I'm sorry, I didn't give you a factual basis for that. They found him, they questioned him, they gave it a fake name. Anyway, on count 2 for the giving false information, 12 months probation concurrent with count 1. Your Honor, based on his history, he has several, the violating TPO is concerning, the burglary is concerning. He was on this woman's front porch looking for something. He obviously scared her. She screamed. Our office has not been in touch with her. However, based on his history and the facts of this case, that's the state's recommendation. And if we could sound for Deanna Garcia at this time, I don't believe she's on the Zoom, but.
Ms. Garcia is on the line and wishes to address the court. Now is your opportunity.
Nothing further from the state.
Yes, Ms. Vigiletti.
Yes, Your Honor. First, just regarding giving a false name, I do just want to say, Mr. Miller, he goes by the name of Cy. He's gone by the name of Cy his entire life. Everyone knows him as Cy. And so, although that is the name he gave the officer, he was just responding to the question of what's his name. We've talked about, of course, you have to give your government name to an officer, but I do not believe it was his intention to deceive the officer. He was in a pretty mentally distressed state when the officers came upon him. He had been at a friend's house nearby, and an incident happened where the police was called, and Mr. Miller was on the porch just trying to regroup. He was considering perhaps going to the hospital. He had a difficult night. Mr. Miller is homeless. He is living outside right now. This is typically a situation where I would attempt to get some kind of program together before Mr. Miller takes a plea, but because he does have a hold in Baldwin County, it makes it really difficult for our office to get that together. Because, we can't get him into a placement and then have the placement be held indefinitely until, his issues are resolved in Baldwin County. What we can do today is give him a list of places and services where he can refer himself when he gets out of Baldwin County, and that is our plan. I have also left a message for his mom, who may be willing to help him out, get his feet back under him. The reason we're asking for the jail portion to be reduced from 60 days to 32 days this morning is that he does have an issue he needs to take care of in Baldwin County. It is a probation violation issue. He likely will be there for some time. He doesn't know Deanna Garcia. Was not his intention to scare her. He has absolutely no problem staying away. He acknowledges he was present on the porch and shouldn't have been. And so, I don't think probation is going to be any problem for him, but, he does have this other criminal matter that he needs to get cleared up. So he will be in custody. We're just asking for him not to be held in custody here any longer, so he can get these things resolved and get his feet under him.
Okay, Ms. Vigiletti, if he wants to take a plea, I think what I'll do is, given his situation and what I've been told about the incident, I am willing to have him serve 40 days, give him credit for the time served, 16 days, balance suspended, so he can go on off to Baldwin County and complete whatever else he has to do there. Then he won't be under probation sentence on this case. And given his situation, it might be difficult for him to do the terms, and he might be right back here. So I don't want to set him up for failure. So it will be 12 months to serve, 40 days credit for time served, 16 days, balance suspended on both charges, if that's what he wants to accept.
Okay, thank you. I could just have 1 second.
Okay.
Okay, Your Honor, Mr. Miller would like to enter a plea this morning.
Okay. Mr. Miller, it's my understanding that in case 24 CR 003093C, you wish to plead guilty to loitering and prowling and giving false information to law enforcement. Is that correct?
Yes, sir.
Are you under the influence of any drugs or alcohol at the present time?
No, sir.
You've been represented by counsel. Are you satisfied with her representation?
Very satisfied.
You understand that you have a right to a trial by jury on these charges and that by pleading guilty to them, you're giving up your right to a trial by jury?
Yes, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Okay, I'll accept your plea of guilty, Mr. Miller. For the loitering and prowling, it'll be 12 months to serve 40 days, credit for time served 16 days. Balance suspended, you to stay away from the 2808 Peachtree Park Drive address, no further contact with Anna Garcia. For the giving false information, 40 days to serve 16 days, 40 days, 12 months to serve 40 days, credit for time served 16 days, and balance suspended. Good luck to you, Mr. Miller.
Thank you, sir.
Thank you, Your Honor.
Next, Your Honor, we have position 26 and position 27, Mr. Bernard Mitchell.
And what are we doing with Mr. Mitchell this morning?
Your Honor, Mr. Mitchell would like to enter a plea of not guilty this morning. I'm happy to file a waiver of his arraignment, and we'd also like to make a bond request.
Okay. Do I have anyone for pretrial line as of yet? Doesn't appear so. Do you have the history? Oh,
Yes,
yes,
Your
Ms. Tyson. Good morning.
Yes, good morning. One moment, Your Honor, I'm pulling his information up right now.
And as you do that, do we know what his current bond is, Ms. Vigiletti or Ms. Desiano?
Yes, Your Honor. I believe he's currently being held under 2 of the 4 of his cases. The 24 CR 001-488F terroristic threats. He has a $10,000 surety bond. And then he has a criminal trespass case, 24 CR 003189Y, where he has a $3,000 cash bond.
Your Honor, he has 29 arrest cycles. They look like they begin in, let's see, 1997. It looks like his last arrest was in Atlanta, April 29th of 2024. And that was for cruelty to children in the 2nd degree. It says upbraiding, insulting, abusing a public school teacher, administrator, or school bus driver. Case was dismissed April 30th of 2024. Let's see. He has a most recent probation violation from 2021. He has a felony conviction out of Fulton County for aggravated assault. Disposition date on that case is June 19th of 2019. Let's see. Looks like and he has 1 additional probation violation within the last 10 years. No other convictions in the last 10 years, Your Honor.
Thank you.
You're welcome.
Ms. Desiano, what are the facts?
So, Your Honor, this case, actually, we were on SEA last week. We had a lengthy bond hearing about this case, and I'll just give you a little bit of background. First of all, the state would object to any reduction in bond. This defendant has 4 open cases involving a school called Hollis Innovation Academy. He has been criminally trespassed from this school since 2019. He has a stay away order from this school from the court in his 21 CR case since 2021. So this individual has been required to stay away from this property since 2019. There are 4 open cases that are involving this school. 3 of them have happened in this year. And then, of course, 2 of them from this year are what he's seeking a bond reduction for. So I'll start with the older case, the terroristic threats case. This is 24 CR 001488F. He had a $10,000 SOB pretrial level 1 that was surrendered May 22nd because of his arrest for criminal trespass. And in that case, it was incident occurred January 30th, 2024. The defendant entered the school. He was making threats to students, saying he was going to whoop their A's and F them up. The school resource officer was talking to the defendant about how unacceptable and inappropriate it was. He was very irate. She had to escort him off the property. She didn't arrest him at that time because the children were also upset. This was in a pre-K class, Your Honor, that he's saying these things to these children. He was escorted back to his vehicle. He was criminally trespassed again. Then there was another incident that happened in April, which is the felony case that pretrial mentioned, where he is in the bus lane, moving all the traffic around and cussing out the school resource officer. That case, I believe, was just transferred back to our office for disrupting public school. And then he was arrested again on May 20th for being on the school grounds again. In this instance, it was May 20th. He was notified. He was seen on surveillance walking the fence line. The school resource officer came up to him, told him that he had a criminal trespass. He responded, "I ain't got no criminal trespass," and said, "Keep playing with me. If you want, find something else to do. I'm going to keep warning you to leave me alone. You don't want these problems." There's a previous case from 2021 where he was cussing out students again. I mean, what came out at the bond hearing on SEA last week was that his children no longer attend this school. He had several family members who were testifying who said that he was there because his wife was having a seizure. Then his wife said she was never there. She doesn't work there. Then he had someone from his church saying that he was at church that day, which is right across from the school. But regardless, the school resource officer said he's on surveillance going up and down the school grounds. So obviously, Judge Mincy was very concerned for the safety of the children. Our office was in touch with the school resource officer who said that she was very concerned for the safety of the children, especially with graduation and everything going on. We don't know why he keeps coming back to this property. He's been ordered to stay away multiple times and he keeps going back. So obviously the state is objecting to any reduction in bond given the circumstances.
Cynthia, the initial $10,000 SOB through pretrial, do you know if I gave him that initial bond?
Was Judge Law.
Okay.
And I'm sorry, I believe the $10,000 is a surety bond.
It's a surety bond now. It was surrendered, but it was initially an SOB pretrial level 1.
Yes, Ms. Vigiletti.
Yes, Your Honor. Currently his family would have to put up over $4,000 to bond out Mr. Mitchell. And our primary reason for requesting reconsideration this morning is the fact that Mr. Mitchell and Miss Houston, his wife, have pulled the kids from the school. So there is no reason for any further incident. Mr. Mitchell is highly motivated to show up for court. He does believe that these are misunderstandings that can be cleared up. He does have a pretty significant reputation in the community at stake. He was actually the president of the PTA, and I can provide this court proof of that. I have the bylaws of the PTA where he is signed as the president. And I do believe there are other PTA members here today to verify that as well. So, it is pretty important to him to get this resolved, show up to court. Of course, this court will consider that he did go back to the school area in violation of the bond order telling him not to, but his wife is here and can, explain to this court that she was having a medical need. She has a chronic medical illness. And did call and ask him to pick her up. He tells me that he did call his pretrial services officer, Miss Morgan, to try to let her know what was going on, that he needed to be near the school to pick her up. He tells me he called the principal as well to ask her to send his wife out so he didn't have to go into the school. The police report does to some extent reflect this, as it states he was on the fence of the property. He parked his car at the church across the street. Although, the officer says that's still within 200 yards. I understand this may have been a violation regardless, but there's some evidence that he was trying not to have any further incidents, as well as pick up his wife, which is why I do believe them pulling the kids from the school is such a compelling reason that they would have no further incident. He is the primary caretaker of his wife and his kids. 3 of the kids go to this school, but he does have 11 total children. His brother also has a disability and lives with the family. So we're extremely, extremely clear on staying away from the school now, but his whole family is having a very difficult time with his in custody. And I also do just want to briefly address, the police report refers to Mr. Mitchell as King Felony. And he did volunteer to me that he has a record from his youth, but as Ms. Tyson said, he's not been in trouble in over 10 years. He's turning things around with himself. And this security officer apparently did know Mr. Mitchell in his youth. So he does believe he's, not being given the benefit of the doubt because of some past that he has worked very, very hard to turn around, hence being PTA president, volunteering at the nearby church, and he's actually also working on becoming a pastor as well. So I do believe there is some community support here on the record, and we're just asking Your Honor to consider reducing the bond, particularly converting that cash bond to a surety, so his family might possibly be able to help him out.
Was there an incident, Ms. Desiano, between position 26 and 27? Is there another charge?
There was, yes. That
What-
is
what
the
was
case
it?
that was a felony. It was originally charged as cruelty to children in the second and insulting or abusing public school teachers / admin / bus drivers. That has been transferred to our office and is now just a disrupting public school.
What's the date?
The date on that one was April 24th, 2024.
And what was his reason for going there on April 24th, Ms. Vigiletti?
I apologize, Your Honor. I was not understanding this case was dismissed, but I'm seeing now that it's transferred. If I could just have one moment.
Okay.
Your Honor, I have the warrant if you want me to read it.
Okay, just a moment, Ms. Desiano.
Okay. And while oh, wait, I have a brief response to some of the things she said, Judge.
I'll give you that opportunity, Ms. Desiano.
Yes. Hello?
Okay, Your Honor, I'm sorry for that.
Okay. Do you have an answer to my question?
Yes, so, Mr. Mitchell is telling me he does attend the church across the street. And he is telling me this is another incident where he was at the church doing work at the church and that he was trespassed again from the school, got into a verbal altercation with the security officer who saw him at the church, and that is how this incident began. But I have not, I'm very sorry, I haven't looked at the documents of this case. I mistakenly believe this was dismissed.
Ms. Desiano?
Your Honor, that's respectfully just not true. According to the warrant, he was there at 7 a.m. He was being irate in the bus lane. The principal said a parent was upset because the exterior gates were locked, which prevented the bus from accessing the main driveway. He came over yelling and cursing. He started moving the signs, the school tardy sign, placed them in the passenger lane, and was saying, we're not going to do that. He started calling the SRO a B word, said she's not doing her job. And why he was in the bus lane at 7 a.m., I have no idea. According to him right now, he was at church. And just briefly, Judge, this idea that he was there because his wife was having a medical emergency, this was fleshed out significantly at the bond hearing at SEA. And he actually had someone come and testify who said that he was at church and he wasn't trying to pick up his wife. And it was because of all those inconsistencies that Judge Mincy was concerned about the veracity of what the witnesses were saying and ordered a cash bond.
Okay. When did he pull the children from the school, Ms. Vigiletti?
The same day that he was arrested on this charge, so I believe that's the 22nd of May. Oh, I'm sorry, the 21st of May. Right.
And I notified Chief.
Okay. Anything further?
Your Honor, oh, I'm sorry.
Go ahead, Ms. Vigiletti.
I did just want to let you know, Miss Houston is Mr. Mitchell's wife and was present, and so she is the person with her hand raised.
Okay. Ms. Houston, let me just say, Ms. Houston, I know Ms. Moore wants to testify in this matter also. I will give you that opportunity, but it's going to be under penalty of perjury. This is being recorded. This is being looked at by the solicitor's office. So anything you say will be under oath, and it will be subject to perjury. As you go forward, if something different comes out, you could be subject to liability yourself. So Ms. Houston, with those instructions, if you want to tell me something, I'm happy to give you that opportunity. Okay?
Yes, Your Honor.
Raise your
Okay.
right hand. Raise your right hand for me. And you can't move around. You have to stay
I'm in the
still.
courthouse. I'm sorry.
Okay, well, you're gonna still have to stay still for me. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Okay, you can place your hand down. What would you like to tell the court, Ms. Houston?
Okay, so for first instance, where the officer said he was walking around cussing in the school, that never happened. And the reason I know that never happened because he was with Officer Bradford the whole time the incident happened with that parent. He never came on school grounds until that young lady decided to call her brother up there to the school because she didn't like Bernard telling her she could not drop her child off at
Okay, Ms.
5
Houston,
minutes.
Ms.
Yes,
Houston,
sir.
I don't want to talk about that because
Okay.
he was told not to go back there. So he was given the opportunity with the signature bond. He was told not to go back there. He was instructed that if he went back there, there was going to be that the bond could be revoked. So apparently he went back there again on April 24th. Do you want to tell me something about that?
This was the first instance. This before that even happened. That was when they gave him the stay away order. That was the first instance of what happened. Okay.
I understand that. So
the
he was just right.
The
So what's
second
the
incident that happened, we were dropping the children off at school. He was never on the grounds. He was never on the grounds. Never on the grounds. He was always on the outside of the gate. The instance where I got ill, I had an event with DOT, the walk and roll event with Miss Nicole Hollis. I was up there early because the children had to get out of school. Once the children got out of school, they were over there with me. I was talking to Dr. Brown, which is the principal, and I started feeling ill. I hadn't taken my medication, plus it was hot. I asked him, please come get me. He walked upside the gate because he was looking for the children because they were running around. It was actually an event where they were giving away free things. Once he saw the children, he told them to come on to the gate. He came when they went to the gate. I looked over to where they was running. They ran to him. I told Dr. Brown, I said, Dr. Brown, I gotta go. I said, there go Officer Price. The crossing guard called Officer Price over there because they seen Bernard grabbing the children. She wasn't even out there. The crossing guard called her, and when she came out there, she told him, you know you're not supposed to be over here. He said, I'm just getting the kids and getting my wife. Just leave me alone, because every time they see each other, she always has something to say. We left. At that point, it was over with. At 7, we called Chief Applin and told Chief Applin what went on. As soon as Chief Applin said he was gonna have a word with her, at 7:47, she go put a warrant out for his arrest. I have that. I have all of that. I was here because I was supposed to meet. I thought I was meeting Miss Olivia to show her all of that. At this point, I have my paperwork for my medical condition. I have his pastor's certificate. I have his disabled brother with me because I wanted you to see this is all that he takes care of everything. He is the sole provider of the house. I can't do this. I haven't taken medication because he's not been at home. I can't do it. I'm tired. I can't do it. I cannot do it by myself. And then not even to mention, we have to be moved out of the house in 2 weeks. We literally have to be gone in 2 weeks. I need him home. I'm asking you to have mercy on this situation and please give him a bond, a lower bond, so we can get him home. The kids no longer go to the school. Dr. Brown is no longer at the school. The principal not even at the school no more. The superintendent literally just got off the phone with me 7 minutes ago.
All right, thank you, Ms. Houston. What's his bond on? What is his bond on the April 24th matter, Ms. Desiano?
Your Honor, I believe it's just a signature bond because they dismissed the cruelty to children second degree and they transferred it to us, and I believe it's just an SOB jail. I will confirm. Yes, Judge, it's a UJR.
Okay. Ms. Vigiletti, I'm gonna leave position 26, the $10,000 good bond as it is. For position 27, with all the same condition. For position 27, I'm not gonna go lower than that. It's gonna be a $10,000 good bond on that charge also. I will convert the cash bond to a surety bond with all the same conditions as is in the cash bond.
Okay, thank you, Your Honor.
All right. Good luck to you all.
Thank you, Your Honor.
Your Honor, can we do the probation revocation calendar now? Position 1 and 2, Atkins?
Yes, I believe that Officer Allen's on the line. Good morning, Officer Allen.
Good morning, Your Honor.
Yes, and good morning again, Ms. Atkins. Let's see, where are we with Ms. Atkins's case?
Your Honor, Ms. Atkinson was sentenced to probation for simple battery, where she was required to do anger management classes. She has failed to provide our office with completion of those classes. It's 275 days remaining on her case, so she definitely has enough time to continue on probation, Your Honor. She has been in custody since May 27th.
And has she been reporting as required?
No, Your Honor, no, she hasn't reported to our office. I'm gonna just confirm. 1 second, if I'm not mistaken, she's never reported. So yes, that's correct, Your Honor. She's never reported to our office. Again, but it is 275 days remaining on her case.
What's the problem, Ms. Vigiletti?
I spoke with Ms. Atkins yesterday. She did tell me that she believes she did them right away when this happened, and so she thought she had done everything and that she was all taken care of. Unfortunately, you know, Ms. Atkins is homeless and does have some memory issues. She was having some trouble remembering where she did that anger management. So what we discussed is redoing it, getting it done, doing 6 more classes and getting that proof to the probation office. Our office does intend to go talk with her today to discuss some housing options so that, you know, she can have someplace safe to live while she gets those done.
Your Honor, now that Ms. Vigiletti just shared that she's homeless, I guess probation will have a issue, or she will have an issue with completing those classes because those classes does cost.
So I do believe, and I could be wrong, but I do believe it is possible to do anger management for free at maybe at 10 Park Place, but I've definitely seen, I thought I'd seen a free anger management before. I can certainly look into it, or Your Honor, if you'd be willing to perhaps convert to some community service. I know Ms. Atkins was highly motivated to get something done and get this behind her, as she thought it was already behind her.
Ms. Tyson, I know that you don't have it. Are you able to get me a history for Ms. Atkins?
One moment, Your Honor. Let me check.
And Officer Allen, do you have the sentence sheet when she was sentenced in this?
Yes, Your Honor.
Could you let me know if she was given credit for any time served before entering
Yes,
the
she was
plea?
given credit for 13 days.
And she has been in custody another 14 days on this probation warrant?
Yes, since May 27th.
Okay.
So I believe that's 9 days, Your Honor.
And Your Honor, this is actually, she only has 2 arrest cycles, obviously the simple battery and the probation violation. Those are only 2 cycles in Georgia. And she does have 15 arrest cycles out of Texas. Her last arrest was in 2017, and that was for, I guess, disturbing public peace, public intoxication. It doesn't state if it resulted in a misdemeanor conviction or not. Let's see, she does have a felony conviction from 2013. That's the most recent, from 2013. Prostitution with 3rd or more offense. And that's April 2013. That's it within like the last 10 to 11 years, Your Honor.
Given her situation, and that she's been in jail more than 3 weeks total, I am going to give her credit for time served, and close the case.
Thank you, Your Honor.
Thank you, Your Honor.
Okay. Good luck to you, Ms. Atkins.
Thank you.
Ms. Atkins, we're still coming to talk to you about housing, okay?
Yes, sir.
I'll
Yes,
see
ma'am.
That's okay.
May I be excused, Your Honor?
That's all we have at ACDC today.
Yes, sir.
Will I see you this afternoon?
Most definitely, sir.
Okay, I'll see you then. Have a good morning.
Bye. Okay, you too.
Your Honor, we're going to continue in the probation calendar,
Okay,
position 3 and 4, Mr. Cordell Canty.
Good morning, Your Honor.
yes, good morning, Mr. Canty. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
Thank you, Mr. Canty. Let's see, who's representing Mr. Canty?
Olivia.
I'm sorry.
Position 3 and 4 on probation.
I apologize, Your Honor.
Oh, you're fine, Ms. Vigilante. Are you ready?
Yes.
Okay, yes, Officer Allen.
Mr. Canty, he was sentenced to probation for the charge of battery, family violence, where he was required to have no contact with the victim and stay away from the incident location and complete domestic violence counseling. He has failed to report to our office. He's failed to provide documentation of the domestic violence course. There's 108 days remaining on his case. At this time, probation recommends that his balance be revoked. Oh, Your Honor, also, he's been in custody since May 28th, 2024.
Ms. Vigilante?
Yes, Judge. Mr. Canty, I think there are two primary problems in getting these probation requirements done. First, there was most certainly a misunderstanding of the requirements, and second, Mr. Canty has had a pretty unthinkably difficult year. So when I went to see him yesterday and explained the Family Violence Intervention Program, he was very surprised. He told me that he got time served on this. And after some further discussion, it became clear that Mr. Canty is a bit hard of hearing and was catching most of what was going on in court. He heard the phrase time served and did not realize that that was not the entirety of the sentence. I'm sure that was on the jail portion of the sentence. He was pretty desperate to get out of jail and did not have a full understanding of what was needed. So we've thoroughly discussed probation requirements now. He understands what is needed. His plea on September 5th of last year did make him homeless. He has had no contact with the victim since. He had no phone and no stable address, so he wasn't getting the mail that I'm sure probation was sending him. He'd been job seeking, but without a home, and was having a very difficult time. He then spent about a month in Clayton County Jail back in January. I don't have the official proof of incarceration, but I did find the docket online where he got credit for a month in jail around the end of January, early February. He then spent about a month in jail in Fulton County in February. And then right after that, his 15-year-old son did die by gun violence. He also did recently lose his mother. And although, all of this has been pretty unthinkably difficult, Mr. Canty is actually on the brink of some level of stability. His passing mother left him an inheritance that is substantial enough to afford him some stable housing, get caught up on, he has a phone now. He would be able to get caught up on any and all probation fees. He has a mailing address, contact information, and recently started the process of job seeking. He intends to drive box trucks. Mr. Canty is very motivated to take some classes and make this as right as possible. Of course, I agree with Ms. Allen, he doesn't have enough time to do FVIP, but he does have enough time to take 12 anger management classes and get caught up on these probation fees. Like I said, he's not had any contact with the victim, so I don't think there's any concern of future danger there. But I do think it could make a big difference for him, from just a mental health perspective, given this difficult year, if he had an opportunity to accomplish something and make something right. So my request today, Your Honor, is to continue him on probation and give him a chance to get some type of classes done, although FVIP won't be possible.
Officer Allen, do you have the sentence sheet?
Yes, Your Honor, he was given credit. I'm sorry, I just had it pulled up. Give me 1 second. He was given credit, looks like, for 25 days.
Okay, and who, can you tell on the signature who signed the probation sheet?
Your Honor, I think it was you. Looks like
Okay.
your signature.
Okay, so that's what that was, and I appreciate your argument, Ms. Vigilante, but and I know that when people come before us, they're represented by you all. I take efforts to make sure that they understand, and if they don't understand, I give additional time to make sure that they understand. I don't specifically remember Mr. Canty, but if I follow my normal procedures, I make sure that everybody understands, and you all also do your job and make sure that everybody understands what the requirements are going to be. So I find that him saying that he didn't understand not to be believable, quite honestly. And as you know, I like to have somebody do something as opposed to doing nothing. So I am willing to convert the DVIP into 12 weeks of anger management. But if he's going to have to report the way that he is required to report. If he misses one report, I'm going to revoke the balance when he comes back. So I will give him a very, the opportunity, but if he does not enroll in anger management, within the first week, if he does not report, as he is supposed to report, I'm asking Officer Allen to, return him to me, immediately, and I'm gonna revoke whatever balance there is left. If he wants to get this behind him today, how long has he been in custody? This time, do we have a number?
8 days as of today, Your Honor.
8 days? 16. If he believes that he cannot abide by the court's request, today I'd revoke 60 days, give him credit for the time that he served of 16 days, and close the case. Do you want to discuss what he wants to do?
Your Honor, Mr. Johnson would greatly appreciate the opportunity to complete anger management. He will,
Okay,
within the first week, he'll be reporting and enrolled within that first week.
okay. Mr. Canty, do you understand that I'm giving you the opportunity? And if you don't do what you're supposed to do, then whenever you come back, if you come back, and I'm hoping you don't come back, I will revoke the balance. You understand that?
Yes, Your Honor, I hear you clearly. Yes, sir.
Okay, you hear me clearly.
Yes, sir.
All right.
I should be there. Can you give me like information to where I have to go?
Miss. Okay. All right. So I'll give him another opportunity. Convert the DVIP to 12 weeks of anger management. He is to report as he is scheduled to, Officer Allen, and if he doesn't, I would like for you to immediately bring him back in front of me, okay?
Yes, Your Honor. Also, Ms. Vigilante, can you make sure we get a good contact number and address for him?
I will,
I
yes.
have a number now. Yes.
All right. Good luck to you, Mr. Canty.
Thank you, Your Honor.
Your Honor.
Thank you. Thank you.
Your Honor, we can go to Joe Court's iPhone.
Okay, and good morning. Who do we have there?
Good morning. We have positions 5 and 6, Mr. Kilgore.
Okay, this is also on the probation calendar. Let's see, who's representing Mr. Kilgore?
I just need him to say first.
That's gonna be Ms. Vigilante. She's on her way.
Okay, thank you. Good morning, Mr. Kilgore. I'm Judge Eric Morrow. This is the probation revocation calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir.
All right, thank you, Mr. Kilgore. Yes, Officer Allen.
The defendant was sentenced to probation for the charge of battery, where he was required to complete a 12-week anger management course, as well as have no contact with the victim in the case. All his probation supervision fees were waived. The defendant has failed to report to our office. He's failed to provide our office with completion of the anger management course. He's been in custody since May 24th, 2024. It's 200 days remaining on his case. Probation at this time recommends that he be allowed to continue on probation.
Okay, Ms. Vigilante.
Your Honor, I actually have not met Mr. Kilgore yet. I looked for him multiple times in the jail yesterday. I looks like perhaps he had been moved. So if I could please speak to him, I just, of course, appreciate the recommendation to continue on probation, but I want to make sure he understands his requirements and get a sense of what's happening before we move forward here. I'm not,
Okay. Do you have a laptop or not?
my laptop does not Zoom. Does your laptop?
We're gonna find out.
Okay, yeah, I can't bring my.
Or I can place you into a breakout room very quickly, Ms. Vigiletti, if.
Get people out of here so I can talk to you. Okay, yes, thank you, Your Honor. If you could put
Yes,
it
sir.
in the breakout room quickly.
Okay, so hold on, Mr. Kilgore. I'm gonna have you speak with Ms. Vigiletti in a breakout room so that you can discuss your case with her, okay? And you can ask her any questions that you have at that time, okay?
But I understand what she said. We don't even have to talk. I understand what the probation lady is saying. I understand.
Okay, but I want you to speak with her so that she can maybe explain some things to you that you might not understand. So, you know, she wants to do her job properly so that she understands and can relate that to the court, okay? So let's place courtroom 2 and jail court's iPhone into a breakout room, and court will be in recess until they return. We ready to continue, Ms. Vigiletti?
Yes, Your Honor.
We can get everyone muted. Victoria Turner, if we can mute that device.
Okay. Hello?
Yes, ma'am, if you can mute your device for me. Thank you. Yes, Ms. Vigiletti.
Yes, I just spoke with Mr. Kilgore. He understands where he went wrong here. He has 12 weeks of anger management to complete. He did tell me, he made some early attempts to report to 132 Mitchell Street, and sounds like the officer needed to reschedule. And Mr. Kilgore made the mistake that we often see folks of just sort of passively waiting for probation office to reach out to him. And he says he didn't get a notice, and because he is working and on felony probation, he just sort of lost track of this misdemeanor probation. And so we've discussed that where to go. We need to get these 12 weeks of anger management classes out of the way and report and be in touch with that officer. And I think he does have 189 days left, so he has plenty of time to get it done. He is highly motivated to get out of the jail and get that done.
And Your Honor, let me make sure I put on record that we did reach out. He reported to our office on May 2nd. He was given a new scheduled report day, as well as provided information about the 12 weeks of anger management classes. We reached out to him on June 5th, 2023, June 6th, 2023. Also an email reminder on June 12th. June the 13th, email reminder on June the 19th, and then we sent him a letter on June the 21st. And once he failed to report after that letter, that's when we did a warrant for his arrest. So let's just make sure we're clear that we are reaching out to the defendant. He just failed to report.
Okay.
Oh.
No, go ahead, Ms. Vigiletti.
I just was gonna tell you, Miss Allen, since Mr. Kilgore has been in custody, his phone is out, but I'll make sure to get you updated contact information for him.
Okay, thank you, Ms. Vigilante.
Okay, so I'll give you the opportunity to make it right, Mr. Kilgore, but if you come back before me, just know that the balance is possible that it will be revoked. So make sure you just go ahead and knock this out so you can get this behind you, okay?
Yes, sir, thank you.
All right, very good. So I'll accept the probation's recommendation and reinstate Mr. Kilgore on probation.
Thank you, Your Honor.
Thank you. Your Honor, that concludes my business for today. May I be excused?
Yes, have a good day, Officer Allen.
All right, thank you.
Who do we have next?
We're gonna go to position number 30, Mr. Solwell.
Okay. And what are we doing with Mr. Solwell this morning?
Your Honor, Mr. Solo would like to enter a plea of not guilty, and we also have a bond request this morning.
Will you be filing a waiver?
Yes, Your Honor.
Okay. What is his current bond?
He currently has a $1,000 surety bond.
What's his history?
It looks like he has one cycle out of South Carolina. That's from 2017 for assault and battery in the first degree, kidnapping, and malicious injury to personal property. Disposition states that it's a non-conviction. Date on that is April 23rd of 2020. And he has one cycle out of North Carolina from 2017. It looks like it was for an out-of-state warrant. Nothing to add, Your Honor.
Ms. Tessiana?
Your Honor, this incident took place May 17th, 2024. Officers responded to 760 Mount Vernon Highway to the Sonesta Suites. A third party called advising that a male was attacking a woman in room 723. Upon arrival, officers made contact with the victim, Victoria Turner. They saw visible injuries to Miss Turner's face and swelling around her eyes. Miss Turner advised that she and her boyfriend got into an argument when she told him that she wanted to break up with him, and he began punching her in the face. She had injuries to her face consistent with being punched in the face, and the defendant fled the scene prior to the officer's arrival, but was located and taken into custody. He does have a surety bond. Judge. Our office has not been in touch with the victim, and he does have that prior. Non-conviction could also mean he was sentenced under first offender, Judge, so the state would ask you leave the bond as previously said.
Okay, I see that Ms. Turner is on the line. Ms. Turner, if you would like to address the court, now is your opportunity to do so. If so, I'll need for you to unmute yourself, activate your camera, and I'll have to swear you in.
Okay.
Okay, yes, good morning, ma'am. Can you raise your right hand for me?
Okay. Okay.
Wait. Yes, do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes. Whole
Okay.
truth.
Yes, thank you, Ms. Turner. What would you like to tell the court?
Basically, the event happened so fast, and basically, me and him, we are still dating. We are currently in a relationship, and I would just say, he was having a bad day. So,
Has this ever happened before?
no.
Are you afraid of him?
No.
Do you all live together?
Excuse me.
Do you live together?
Yes, we currently do.
Okay. Thank you, Ms. Turner. Ms. Vigiletti?
Yes, Judge, and my primary reason for requesting a signature bond this morning is that Ms. Turner and Mr. Sowell have both asked me to. They've both separately told me the same thing, that they are still together, they intend to stay together. They're happy to comply with, any bond requirements such as, staying away from the hotel that they were in when this incident occurred. As you heard, Mr. Sowell doesn't really have a criminal history. He does have a couple of job applications pending. He drove for FedEx for 4 years in North Carolina, and so he has an interview supposed to have one this week, but thinks he can get it back with FedEx here. He also has an application pending driving for Amazon. It is his son's 4th birthday on June 24th, so of course he'd like to be present for that. Yeah, it's my understanding that they've been together for 1.5 years and have had no prior incidents.
Okay, Ms. Vigiletti, I'll convert the good bond to a $5,000 signature bond through pretrial level 1-day anger awareness, no further violent contact with Ms. Turner, and no drugs, alcohol, weapons while out on bond.
Thank you, Your Honor.
All right, good luck to you, Mr. Sowell. You also, Ms. Turner.
Thank you.
Judge, did you say no further contact or no further violence?
No further violent contact.
Thank you.
CO, it might be Joan Isles, and the call or text to 770-842-547, which is my cell phone. Please text me first, so it's not, just a spam call. 770-842-547, discuss with Stormwater County Code and our CO, CAPP, and get a waiver. Confidentiality application. Just a nature conversation.
Your Honor, all I have in courtroom 2 is position 14 and 15. And that's private attorney, Miss Renee Rockwell. She said she had been signing on shortly. She had to run to another court.
Okay. So you all let me know when you're ready to proceed.
Your Honor, I have an announcement.
Okay.
On number 1, Mr. Christopher Amos, he has a arraignment tomorrow scheduled, but he also has a separate felony case that could involve possibly the same address. Therefore, I must consult with that felony attorney to make sure that we're on the same page. I don't want to mess their case up. If we could reset that a week, that would be greatly appreciated.
Okay, position number one, Mr. Amos, will be reset until June 11th.
June 11th. Thank you. Your Honor, our announcements on other people, we've got a couple of not guilty's bond requests, and so we'll just wait.
Okay,
In the meantime, we're trying to get that Hill information.
thank you. Ms. Desiano, positions number 14 and 15, will there be a DA transfer or?
Judge, I believe that's Ms. Fox's case. Yeah.
It is, Your Honor. 14 and 15, let's see. Mr. Elliott, so I know that, let me just double check on number 15. I know number 14 is not being transferred. It's number 15 that we applied for a DA transfer.
Okay.
Number 15, what, wait, let me just double check. Okay, so it does seem that there is a case that's already upstairs from January 28th, 2024. Let me just double check and see what the DA's office responded on Elliott's other case.
Okay.
Mm-hmm. So I have not received a response from the DA's office, so I'm reaching out to them right now, just to reinitiate contact. We did send them the information. They asked for also the warrant, which I sent them, and I have not gotten a response since then. So I'm just going to reach out to them really quickly and see if they can go ahead and sign the transfer order that I attached now that they have all of the information.
Okay, thank you, Ms. Falk. I appreciate it.
Not a problem.
Who do we have at medical?
Position 31, John Taylor.
And Mr. Taylor is not being represented by counsel. Yes, good morning.
Or we believe he's pro se because it's citation only and we received instructions.
Good morning, Mr. Taylor. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Good morning. Yes, I guess, yes.
Okay, let's see. Mr. Taylor, you have a right to remain silent. Anything you say can be used against you. You have a right to have an attorney present at these proceedings. You're charged in case 24 CIT 000868 with failure to maintain insurance. Is Mr. Taylor being held in on anything else, Ms. Desiano?
Yes, Your Honor. I believe he is serving a year. I believe he's waiting for a bed at RSAT for a different case. The plea recommendation for this case is just a $350 fine.
Okay. So, Mr. Taylor, it's my understanding that you're in custody on another matter. The state is requesting a $350 fine on this failure to maintain insurance. If you would like to accept that, then you would have to be on probation until you paid the amount off, and then the probation would terminate. If you would like to have a jury trial on this matter, then I can entertain a bond request. Is there a bond?
I
Go
don't need
ahead.
a bond, I don't need a bond, Your Honor, because I had insurance. That's the purpose they sent this over here, because I had insurance in my phone. I had insurance from General. The day the police stopped me, he let me go. He said, if you didn't have insurance, I was gonna tow your car. And he looked at my phone and seen it was there, and he let me go home.
Okay. So, Ms. Desiano, given that, I want to give him the opportunity to present whatever evidence that he has to your office. I'm sure that he's going to have to do that when he gets out. Would the state object to a signature bond on this matter?
No, Your Honor. I believe he is serving time though, so.
Right, so that when he gets out, then he'll have that signature bond so that he can come back at a later time and present any evidence that he has to yourself or to the court. So it'll be I'm going to give you a signature bond through the jail, $1,000 signature bond through the jail, Mr. Taylor, and you'll be able to come back once you get out of custody to address this charge, okay, and present any evidence that you have. Okay.
Your Honor. Did the letter ever go to my mother's house? Because she said she didn't need no letter for me to go to court.
Okay, well, before you get out, we'll make sure that we have your proper address, okay?
I
So
gave
we
it to
don't-
him.
Okay, well, we'll try to get it to him again, okay?
I
And
get
then
out
another
October
station-
28th. This is not gonna hold me in here because I don't want like 3 months left.
Okay, so I'm giving you a signature bond, so you won't be held in on this charge, okay?
Okay, thank you.
And Judge, he shouldn't have gotten an email for any court dates anyway. This case was a bind over and it was just accused a few days ago, so I doubt an email's gone out.
Okay,
So if
All
I was on
right.
the street, how would I know to come to court then?
okay, do you have an address once you
Yeah,
get out?
Yeah, I gave
Okay.
it to the people before I left the courthouse downtown.
Okay, so we'll make sure that we have your proper address, Mr. Taylor. And if you want, let's see, Miss Grace,
Yes.
if we put his address in the chat, can you make sure that it's updated?
Yes, sir. Also, who's gonna send over the, Mr. Jordan is here as well. Who's gonna send over the bond order? Because it's not represented by no one.
Okay,
I can do that. I can do that, Judge.
okay, thank you, Ms. Desiano.
Please and thank you, yes.
And I'm
Oh.
showing his updated address is 555 McDaniel Street, apartment 4239,
That's
Atlanta.
it. Yeah.
Okay,
My mama
all
house.
right. So, Mr. Taylor, we have your proper address. Once you get out, you'll get notice of your court date for this, okay?
Okay, I just want to appreciate y'all guys, and hopefully my stuff will be here so I can get out of here. I want to be held up before the county will keep you here 10 days overdue.
Okay, all right, good luck to you, Mr. Taylor.
Good morning, Your Honor.
Yes, good morning.
Yes, my name is Angela Davis. I just want to know, do you have anybody named Courtney Davis on your list this morning? He's in
Yes.
medical.
I do not have a Courtney Davis this morning.
Okay, thank you. You're probably in another courtroom.
All right, have a good day.
You too now.
Okay, who do we have on the jail court side phone?
We have, position number 16, Mr. Goodman.
Yeah.
Good morning, Mr. Goodman. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes, sir. Good morning.
Good morning, sir. Yes, what are we doing with Mr. Goodman this morning?
The offer was 12 months to serve. Our announcement would be not guilty bond request. Your Honor, he has a $1,000 surety bond currently on a simple battery count and a $2,000 surety bond available on a battery count. So that's a total of $3,000. $350 to a bonding company would take care of that, but he does have the other matter. When the DA's office, we believe, when the DA's office realizes the lack of merit in the possession of firearm by a convicted felon charge on which he currently has no bond, at that point in time, he can avail himself of the bonds that exist. And at this time, we would like to ask the court to consider lowering those bonds from 3,000 total to something in the neighborhood of 1,000 total surety bond.
Mr. McLean, I think this might be a little premature. Why don't you bring it back before me if and when those other charges are resolved, and then I will take a look at these charges. But while those are pending, I don't see any necessity to lower these bonds at the present time.
Understood, Your Honor. We did discuss the concept of temporary mootness. Thank you.
Okay, so good luck to you, Mr. Goodman.
All right, thank you, appreciate it. That's it.
So Judge, what are we doing with these two? I mean, this case?
It appears that a waiver will be filed by Mr. McLean on the case, and that this will be further notice to jail jury.
Jail jury will file a waiver. I have his permission to sign the waiver form for him.
Okay. Who do we have next?
We have positions 3 through 7, Mr. Fuller.
Those are negotiated pleas. He's already, I don't have to sign for him. He signed them himself today. Or yesterday, rather.
Okay, good morning, Mr. Bullitt. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video. Do you agree to have your case heard by video?
Yes.
Can you hear? Okay, thank you, Mr. Bullitt. Can you raise your right hand for me? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, Mr. Bullitt. Thank you. Ms. Falk?
Yes, Your Honor. On position 3, it's going to be for the criminal trespass, 2 days, credit for time served, balance suspended, stay away from 3260 Donald Lee Hollowell Parkway. On position 4, criminal trespass, 2 days, time served, balance suspended, stay away from 1935 Allison Court. In position 5, the criminal trespass, 2 days, time served, balance suspended, stay away from 2110 Campbellton Road. Positions 6 and 7 will be null prost. Upon the entry of this plea, we would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
For the purposes of these pleas, we do so stipulate. Your Honor, the problem has been panhandling. We discussed how this isn't working and he has to stay away from 3 places. He knows the addresses now of the 3 places. He has those in writing so he can stay away. And he's going to have to find a different way of getting social services other than from the public.
Does is he residentially challenged, Mr. McLean?
Yes, Your Honor, this time he is.
Okay, if we could get him some services, or if you can help provide him some services to assist with housing, it'd be greatly appreciated.
I do have some phone numbers of contacts, and we will try to coordinate that. But he is well aware that he's got to not. This will just continue in other places and be panhandled. So this isn't working.
Okay, Mr. Bullard, it's my understanding that in case 23 CR 005406E, you wish to plead guilty to criminal trespass. In case 23 CR 006209E, you wish to plead guilty to criminal trespass. And in case 24 CR 003171E, you wish to plead guilty to criminal trespass. Is that correct?
Yes.
Are you under the influence of any drugs or alcohol?
No, sir.
You've been represented by counsel. Are you satisfied with his representation?
Yes, sir, I'm satisfied, sir.
Yeah. You understand that you have a right to a trial by jury, and that by pleading guilty, you're giving up that right to a trial by jury?
Yes, I understand, sir.
Has anyone forced or coerced you to plead guilty?
No, sir.
Was that a no? Can
No.
you hear me? Are you with me, Mr. Bullard? Can you
No,
hear me?
nobody forced me.
Okay. I'll accept the pleas as negotiated, Mr. Bullard. You know that if you go back out there and you panhandle, you get picked up again, you're just gonna be right back where you are, okay?
I understand,
So
sir.
I'm gonna have Mr. McLean try to provide you with some services so that maybe we can get you some housing, okay?
Yes, sir.
All right, good luck to you, Mr. Bullock.
All right, sir.
All right.
Okay, ACDC is on,
Who do we have at medical?
Position number 30, Ms. Prather.
not ACDC, Ms. Ray.
I have Miss Prather as position 29 on my calendar.
I'm sorry, position 29. I'm so sorry.
No, you're fine. I just want to make sure that I got the right person. What are we doing with Miss Prather this morning?
Ms. Desiano, I sent a very late email last night, because I think Ms. Prather is a good candidate for MH Court. And so I'm hoping that we can get our referral to MH Court today.
Yes, PD Vigilante, our office has been in touch with the victim this morning and she is agreeable to MH Court. I believe if we can reset this case to Thursday and then MH Court can evaluate her.
Is that what you want to do, Miss Vigilante?
Well, Your Honor, I did also, it's tough. This case is tough. As you know, Ms. Prather is 17, so we've been trying to find her someplace safe to stay while we get her set up with services related to MH Court. I did just this morning text for a bit with somebody who it might be safe for Ms. Prather to stay with. I would, of course, like to have that person come to court and, so that you can verify that she's an adult and is responsible and that Ms. Prather could stay with her. So I wanted to make a bond request this morning, but Thursday might be better and then I can get Ms. Prather's safe adult here as well and we could discuss a signature bond then.
And Your Honor, I believe we'd actually have to reset it to next Tuesday because she's going to MH Court on Thursday. And they'll determine whether or not she's released. But the issue, Judge, if you'll recall, this case was on SEA for before you went out of town. We had to reset it several times because the victim is the mother and she didn't want contact and there was a housing issue.
Right, I remember.
Right. So, I mean, I'll defer to the defense, but I know there's possibly a safety issue with her being released. And if she does have a safe place to go, then maybe that can be addressed when the case is reset.
So if she goes to MH Court Thursday, they can address bond, they could possibly address bond there? Is that?
Ms. Falk, can you turn on your camera?
I just don't want to leave her indefinitely.
Yeah, so MH Court asked that she not be released and they can address bond at that time when the case is reset next week, is my understanding. Ms. Falk, is that correct?
Yes, actually, Your Honor, I reached out to Miss Corley once Miss PD Vigilante let me know that she wanted her to go to MH Court. Miss Corley is the person who runs MH Court in conjunction with the judges and the rest of the team. She's indicated that because 7 out of 10 times when somebody's released, they're not able to do the evaluation. She's asked that she remain in custody until Thursday. They have already sent an email to the providers to go out to the jail today to do the evaluation. And on Thursday, they will be able to make the determination whether she can be accepted into MH Court.
Okay, great. So I'm glad that you all have moved that along. So we'll reset her until Thursday. And Ms. Vigilante, if you can, I guess, get whatever you need to get ready for that for placement. Okay, so we'll reset Ms. Prather's case until Thursday. We'll see you back on Thursday, Ms. Prather.
So Ms. Prather, you're gonna have an eval like we talked about, and I did get in touch with Amanda, so I'm hoping she can come Thursday. Okay.
And Your Honor, the only issue with resetting it to Thursday is she has to go to the MH Court on Thursday. So
Yes.
I don't want these two things to conflict.
Yes, we're gonna put her on next Tuesday's calendar.
Yeah.
Judge.
Okay.
Okay, I have a question. Do we need position number 11 and 12, Mr. Marco Kopp?
Oh, let's see.
That's Ms. Fox's case. Let me see.
On that, we are not ready to announce the guilty versus not guilty part. We do see what the bond is, but we have a situation where we need to get some medications straightened out. We don't want to go into detail on that on the internet. We could do a short breakout room in confidence, but it's simply a getting ready situation.
The question is, do I need to go get this man before I leave this floor? Do I need to go pull him?
I would say not. We've got a social worker request in. That's going to be an absolutely necessary thing before we can move forward.
Okay, so you're asking for a reset, Mr. McLean?
Yes, sir, essentially.
Okay, so when would you like me to reset him to?
Either 2 days from now or a week from now.
Okay, why don't we just reset him for a week, and that will be on the 11th.
Very good, June 11th. Got it.
11th. So no, we don't need him today. Thank you.
Thank you, Your Honor.
And while you're there, Mr. McLean, position number 19, Archie Hollis, you're requesting a 2-week reset.
Yes, Your Honor, we have to consult with a different attorney on that as well.
Okay, so that's Mr. Hollis will be reset until 6/18. I see also that on position number 19. No, on position number 20, Jeffrey Jacobson, you're asking for a reset also.
We believe 1920, despite the name discrepancy, is the same. We're trying to check on that, double check, but we think 19 and 20 are the same person.
Okay, well, we'll reset both of them until the 18th.
Thank you.
Are we gonna have anyone on from Union City today for position 24, Mr. Matthew?
Your Honor, I just called them and I sent them the email to log on, so hopefully they'll be logging on shortly.
Okay, thank you. And are you still there, Ms. Vigiletti? I'm sorry, I didn't mean to interrupt you. I just wanted to position 28, Pierre. What are we doing with Mr. Pierre today?
Yes, Mr. Pierre would like to enter a plea of not guilty. He did give me permission to waive his presence as well as his arraignment. So I will file that after court.
Okay, so his case will be returned to the division. Okay, thank you. Let's see, who do we have on jail court's iPhone?
We have position number 13, Mr. Crumley.
Okay.
Okay, ready. That's a bond request, Your Honor.
All right. And you're gonna file a waiver in this also?
Yes, Your Honor, we will.
Okay, what's the current bond?
Currently, Your Honor, it's a $2,000 cash bond on this case. He also has a $12,500 total felony bond on a felony matter. So the cash bond of $2,000 is equivalent really to a $20,000 surety bond. And we're going to ask the court to consider changing that to a surety, even if we have to go up in the actual nominal number to 3,000, 4,000, 5,000, it would still, I think, put it more in line with what's going on.
Tyson, what's the history?
This is Crumbly, position 13, Your Honor.
It is.
There's 7 arrest cycles beginning in 2009. He does have a felony conviction outside the 10-year period from 2010, theft by receiving stolen property, armed robbery. Looks like multiple counts of armed robbery, financial transaction, card fraud, aggravated assault, possession of a firearm or knife during the commission of hijacking a motor vehicle, conspiracy to commit a felony. And it looks like he was sentenced to probation for 10 years and confinement 10 years. So I'm not sure if he's still under active probation or not. I'm not sure. Let's see. Looks like he had a warrant out of Clayton County. Disposition just says warrant issued January 24th of 2024 for misdemeanor willful obstruction. So that may be a possible open case out of Clayton County. He has another felony conviction out of Fulton County for aggravated assault, cruelty to children in a 3rd degree, criminal trespass, cruelty to children in the 2nd degree. No, I'm sorry. Cruelty to children in 3rd degree. I'm sorry. And battery, family violence, 1st offense. Disposition date on that case is March 20th of 2023. And he had probation for 4 years on that case. And his last arrest was May 17th of 2024. Franklin, out of Franklin Police Department for giving false name, address, or birthday to law enforcement officer. No disposition is listed on the GCIC for that case, Your Honor. Let's see, and he does have a warrant. Yep, that's the same warrant out of Jonesboro. And it's failure to appear. It's for a failure to appear, Your Honor. Nothing to add.
Paul?
Yes, Your Honor. It was actually Judge Mincy who ordered this bond May 23rd. And just to give Your Honor some context about why this bond was very much deserved, the 23 SC 185896 case with the aggravated assault and multiple cruelty to children in the 3rd degree was against the same victim in our case, Miss Bianca Marshall. As part of his conviction, on March 20th of 2023, where he was ordered to have a 5-serve-1 sentence. I'm looking at the conviction right now. It was family intervention program within 12 months of release. No violent contact with victim Bianca Marshall, no violent contact with Trevion Marshall, Tavares Marshall, and the other individuals who were named in the accusation, in the indictment. Additionally, on January 22nd of 2024, the defendant is currently in custody on the felony. It's a 24 PI case. To be specific, the case is 24 PI. Let's see. Just pull that up really quickly to give Your Honor the case number.
Yeah,
it's 24 PI 003589 for family violence battery, 2nd or subsequent offense, felony, and 1, 2, 3, 4, 5 counts of cruelty to children, naming basically naming the same victim as well as the same children from the felony conviction for aggravated assault and multiple counts of cruelty to children in the 3rd degree. So this incident happened January 22nd of 2024. And then the temporary protective order violation happened February 21st of 2024. So less than a month after he was charged with, he wasn't arrested on the case yet, but a month after he was charged with family violence battery against the same people he had aggravated assault on, he then violated the protective order on February 21st. In that case, in our case, it is alleged that according to the officer's body camera, Miss Marshall stated she had spoken with her children's father over the phone, and he came to her home. They argued, he left. She had a protective order against him. The daughter, CM, was also on the scene. She said she had seen her mother arguing with the defendant. The protection order was issued on February 2nd, 2024, and served on February 5th, 2024. So that was after the family violence battery, and it expired February 26th of 2024. So while that was the TPO was in place, he then went back to her residence and had an altercation with her, a verbal altercation with her. So this, I mean, the Ayala factors are definitely here. We have a risk of reoffense. We have intimidating our witness. We have the fact that he is has violent felonies already that he's been convicted of and continues to rack up cases involving the same victim and her children. We are asking that this bond remain as set for the safety of Miss Mitchell and her family members, and we are asking that there be no further contact whatsoever. That's the state's representation we would like to sound for Bianca Mitchell at this time.
Ms. Mitchell's on the line and wishes to address the court. Now is your opportunity. Anything further, Mr. McLean?
Nothing further, Your Honor, just the logic we presented.
Okay, given what I've heard, I'm going to leave the bond in place. There's been no change of circumstance. All right, good luck to you, Mr. Crumbly.
Is he all set?
Yes, we're done.
Mr. Crumbly, should I sign a waiver of your arraignment so you can go to jail jury? That was the question. Should I sign for you a waiver of your arraignment on this count of misdemeanor charge?
I don't know what you're talking about. You ain't even give my folks the link, man. So my folks can be on here. You ain't even speaking up for me or nothing. You let these people, I ain't never even been served in it.
Understood. Your Honor, I don't think I have authority at this time to sign a waiver of arraignment, so we might have to talk further.
Okay, so let me just go ahead and arraign him now.
He walked away.
Oh, okay. Well, we'll have to arraign him at some point in time. Can we get him back?
They need you back. No, hold on. Here, he's coming back.
Okay, thank you. Mr. Crumbly, I just want to address you. I'm Judge Eric Morrow. This is the state all-purpose calendar that we're conducting by video today. Mr. Crumbly, you've been charged in case 24 CR 003191J with violating a family violence protective order. This charge carries with it a maximum penalty of 12 months in jail and/or $1,000 fine. Do you waive formal reading of the accusation, Mr. McLean?
I need to get his authorization to do that, Your Honor. Mr. Crumbly, do you want to waive the formal reading of the page that is I
What you mean by waive? Explain.
Well,
I can either read to you what you're charged with, Mr. Crumbly, or you can not have me read. If you want me to read what you're charged with in the accusation, I'm happy to have Ms. Falk do that. If you don't want to do that, then I won't.
No, I'm straight. If y'all ain't gonna ask me what happened.
Okay, well, you have a right to remain silent, Mr. Crumbly. Anything that you say can be used against you, so it's probably to your best interest that you don't speak. This is just an arraignment and a bond hearing this morning. As such, I believe that you say that you don't want the accusation read to you. Okay. And how do you plead to the charge of violating a family violence protective order? Guilty or not guilty?
Not guilty.
Okay, I'll record your not guilty plea, Mr. Crumbly. Your case will be returned to the division judge and you'll get notification of your next hearing date, sir. All right, have a good day. Who do we have at the South Annex? This Mr. Matthew?
Yes.
Yes, sir.
Position number 24.
Okay, and let's see. What do you all need to speak with him, Ms. Vigilante?
Yes, Your Honor.
Okay, how would you like to accomplish that?
I was actually thinking about this. Is it, Officer Norris, I'm sorry, is it possible to do a breakout room? Okay, so we're gonna clear this room so we can speak, Your Honor.
Okay, so Mr. Matthew, I'm going to put you into a breakout room with Ms. Vigilante so that you all can talk about your case, okay?
Okay.
All right. Court will be in recess until courtroom 2 returns. Yes, Ms. Vigilante, what are we gonna do with Mr. Matthew this morning?
Your Honor, I spoke with Mr. Matthew briefly, and I did look into this case yesterday. I believe I only have an accusation, and Mr. Matthew doesn't have a significant memory of this either. So if today, Ms. Falk or Ms. Dociano, I could just request, some documents. It's probably because this was just recently accused, but I don't have a police report or anything that documents what happened. So Your Honor, if we could possibly reset this case, Mr. Matthew will be held until July 2nd on a separate matter. So resetting him a week or so doesn't prejudice him. And if you could please share some documents with me, we could take a look at this case.
Okay, so you say he will be in custody at least until July 2nd? So why don't, if you don't mind, why don't we reset it for Tuesday, the 18th? I'll be back on that calendar on the 18th. Is that okay with everyone?
Yeah, no problem. So Mr. Matthew, I'm gonna come see you in person on the 17th, and hopefully I'll have some more information about what this is, and we can talk on the 17th, okay? Okay.
And PD Vigilante, you need documents from the simple battery case or the add-on case?
The simple battery and disorderly conduct from last month. Thank you so much.
Okay, we'll see you back on June 18th, Mr. Matthew. Anyone else that we can take?
No, not right now, Your Honor. Let me try to get in contact with Ms. Rockwell.
Okay, and let's see, is on the Galaxy A11, is this Mr. Lewis? Yes. Good morning, Mr. Lewis. Let's see, Ms. Vigilante or Mr. McLean. This is the DV bench warrant case. Who's representing Mr. Lewis?
I do, Your Honor.
Have you had the opportunity to speak with him?
Yes, Your Honor, we have.
Okay, are we ready to move forward with this?
Yes, we are.
Okay, Ms. Desiano, are you handling this for the state, the DV bench warrant case?
I am, Your Honor.
Okay, good morning, Mr. Lewis. Let's see, can you unmute yourself for me, please?
Can you hear me?
Oh, yes, I can hear you now. Thank you,
All right.
Mr. Lewis. Ms. Desiano, I'll take it that Mr. Lewis missed the court date.
He did, Judge. He FTA'd the plea and arraignment calendar for Judge Roth on May 21st of this year.
McLean, so what's the reason?
Your Honor, he never did. This was not a situation of missing mail because of changing an address. He got hold of pretrial folks named Gomez and Uten, and apparently it changed from one person to another. And he has told me that they have said that he did not get notice. His address is the same as before. We can put that in the chat. We don't know of any reason why they didn't send notice, but he said he didn't receive it because he was told it wasn't sent, and it may have had to do with simply a personnel change or a change in assignment of a pretrial release officer. And Your Honor, I have an email for him, I have a phone number for him, and I have his address.
Okay, do we have, Ms. Desiano, do you know whether, do you have that he was actually served?
Your Honor, I'm looking at the notice. It's in the docket. It says it was mailed April 8th of 2024 to 174 Georgia Avenue Southeast, Apartment 507, Atlanta 30312.
Did it get returned? Because that is the correct address.
I'm not seeing anything on the docket that shows it was returned.
Okay, so I'm not sure what happened, Mr. Lewis. I give people one opportunity. If you'll need to constantly keep checking with the court to see if you do have a court date.
Oh, I will.
Okay, so I'll give you the opportunity. I will set aside this bench warrant today. But if you miss another court date, then the bench warrant won't be set aside, okay?
Understood. Am I able to still check down into the clerk's office on 160 Prior Street, first floor, just make sure like my court date is set and everything like that? Because that's who notified me about the missed court date, and they the one that told me like, yeah, you wasn't notified by pretrial release, and they gave me the paperwork to actually come and get assigned another court date for today.
That is
Okay.
That's exactly the place. If I were you, I would be there in person. Once every 3 weeks, I'd be there in person checking.
Roger that.
Okay. So,
Your Honor, and just for future, he is still assigned to Officer Uten with pretrial, but pretrial, we don't mail out the notices don't come from pretrial. They come from
Right.
the clerk's office.
Right.
Right.
So you should get a proper notice from the clerk's office, Mr. Lewis, and not rely on pretrial to inform you of the court date. But now that you have an understanding, again, we'll set that aside, and good luck to you, sir.
Roger that. Thank you, sir.
You're welcome. Have a good day.
You too.
Yeah, I take it that there's no one else that we can take right now.
Right. I've been trying on Mr. Hill to get some documentation. Haven't reached anybody yet that can provide it.
Okay, positions 21, 22, and 23. Is Ms. Vigiletti there? Do you still need to talk with
Yeah,
with Ms. Jones?
her case has been reset several weeks in a row now, but I do believe she's at Georgia Regional today. So they weren't able to locate her yesterday, and then today Deputy Milton confirmed she's at Georgia Regional.
Okay, what would you like for me to do with her case today?
If we could reset her one more week, Judge, she's been refusing to speak to me. I'm gonna try to speak to her through a letter, see if she will come and talk to me.
Okay, so Ms. Jones, positions 21, 22, and 23, we will reset until June 11th.
Thank you, Judge.
Okay. So I have that we're holding on position 16, Mr. Goodman. Position 26, Mr. Mitchell, and 27. And also on Ms. Rockwell's cases.
Position 26, Your Honor, we've already addressed. That was the bond hearing with the private school.
Oh, okay, thank you. So 6.
16.
So on
Yes,
16.
I'm showing we're holding on Renee Rockwell's cases and the 2 from 17 and 18 from Mr. McLean. Those
Right.
4.
So, but we already handled 16, right?
Oh, yeah, 16.
We already
16 we handled. And 17 and 18.
That's Mr.
That's
Hill.
right. And it's my understanding that you're going to provide information to the solicitor's office regarding his being in custody at the time.
Right. Specifically, I've been trying 2 phone numbers of his family who we believe may have documents in their possession. I'm also trying the Fayette Jail Records phone number. So between those 3 entities, maybe the last of the 3 might be the most reachable.
Okay, so why don't we do this? Why don't we reset that until Thursday? But if you get the sign off, if you all get a consent together before Thursday, I'll go ahead and sign it as soon as if you all reach an agreement, and it'll be taken off that calendar. How does that work for everybody?
Yes, thank you, Your Honor.
Yes.
Okay. So aside from Ms. Rockwell's case, I think that will complete the calendar. So why don't we go over the calendar while we await Ms. Rockwell's return.
Okay, Judge, just one moment.
Okay. And did you hear anything back from the DA's office, Ms. Falk?
Your Honor, I have not, but I did send a message to the executive director, just letting him know to look at that case real quick.
Okay.
I did a read receipt and it doesn't appear that they've opened it yet, but I just forwarded a text message to him requesting that he go back and look at that one.
Thank you.
Okay, thank you. Judge, I'm ready.
Okay.
Position number 1, reset 611 SAP. Position number 2, 3, 4, 5, 6, and 7 were all pleased with 6 and 7 being non-process. Position 8, 9, and 10 reset further notice. Defendant was released. Position 11 and 12 reset 611 SAP. Position 13 was arraigned, reset jail jury. We are holding on positions 14 and 15. Position 16, reset jail jury. Position 17 and 18, reset 6 SAP. Position 19 and 20, assuming they are the same persons, reset 618 SAP. Position 21, 22, and 23, reset 611 SAP. Position 24, reset 618 SAP. Position 25 was a plea. Position 26, position 26 and 27, reset jail jury with an amended bond order for position 27 of $10,000 good bond. Position 28, reset jail jury. Position 29, reset 611 SAP. Position 30, reset further notice, amended bond order of $5,000 pretrial. Position 31, bond order 1,000 SOB, reset further notice. Any questions, comments, or concerns?
Okay.
Your Honor, if I may make a request on Mr. Cortez Elliott.
Yes.
I may not receive a response before court concludes. If I may ask that we just do a 2-day reset to June 6th.
Okay. I think that's prudent, given that we're at the end of the court session, and that'll give you also the additional time to get that done. So, Officer Norris, if we can just inform Ms. Rockwell that the case will be reset until Thursday.
I'll let her know, Your Honor.
Okay. All right. Thank you all. Anything further this morning?
Nothing.
If not, you'll have a good rest of your day.
Thank you. You too.
See you next time.
You too.
Thank you.
Are you guys the same with her?